it's easy to think about these things as miscarriages of justice as sort of abstract notions. A miscarriage of justice is harm inflicted by the state, by courts, on individuals that devastate their lives. A prosecutor, including a private prosecutor like the Post Office, assumes the mantle of the state. A prosecution is a state function, and the coercive power of the state in the consequences of prosecution are engaged. And in 4 lines of text in a very long document, I saw that the Post Office main board had been notified of concerns about the person who gave evidence against Mrs. Misra at her trial in 2010 about both the completeness of his evidence and the completeness of disclosure. So when you put those 2 things together, you've got a board linkage and you've got a linkage to the person who gave evidence against Mrs. Misra at her trial, which I knew in any event to have been, in respect, misleading evidence. And it was withheld from all those the Post Office prosecuted. And of course, the appeal basically found the Post Office was engaged in conduct that subverted the criminal justice system. The question is, why did the courts routinely fail to recognise that the evidence before the court that was being put forward by the Post Office was incomplete and unreliable? Why you've got hundreds of people in the United Kingdom being prosecuted on a false basis and wrongly convicted and sent to prison, with all the consequences that follow from that. Ordinarily, you would think that there would be an urgent drive to establish why it happened and to make sure that it bloody well never happened again. I suppose I should say a few words about how I came to be involved in the Post Office saga. I had the misfortune, but to every cloud there is a silver lining. I had the misfortune in 2017 to be diagnosed with fairly advanced metastatic cancer. And as a result of having to undergo the usual and predictable volume of surgery and chemotherapy and such like, I really had to give up my ordinary practice, which had been in civil law. Really, I knew very little about criminal law until quite recently. But I had a lot of time on my hands, and I was very interested, and I have been for years interested in how large institutions are able to stonewall in the courts and avoid liability, frequently very successfully. And I'd been looking for some time at the Lloyds Bank Reading scandal, and I came across Mr. Justice Fraser's Horizon Issues judgment, and from that, I looked at the only other civil case that I was able to identify, which was a civil judgment against Mr. Lee Castleton in 2007. He had been sued by the Post Office for a very, in the scheme of litigation, a small amount, but obviously in personal terms to him, a large amount. He'd been sued for £26,000 in his Bridlington Post Office in 2006. And he himself had rung the Post Office helpline, the Horizon helpline, on innumerable occasions, explaining that he had got balancing problems at his account. He's a very astute man, very careful, and he drew an absolute blank with the Post Office helpline, which provided no assistance or support of any kind. He went to a civil trial, which became a High Court trial, and the trial judge in that case started with the disastrous proposition that the account that he had stated at his branch was an account in law, and therefore the burden was on him to show why it was wrong. By this stage, Mr. Castleton had run out. I think he'd spent more than £60,000 in legal costs and had run out of money. So he appeared in the High Court without representation against, I think the firm was Bond Pierce at the time. It's now Womble Bond Dickinson, which is the law firm that conducted the Post Office's case in the High Court before Mr. Justice Fraser, and it was that firm that denied the relevance of the Fujitsu known error log. But Mr. Castleton was successfully sued for £26,000, and the judge in that case, bizarrely in the light of what is now known from Mr. Justice Fraser's judgment, he concluded, without hearing expert evidence about it, that the Horizon system was working perfectly at the time. Now, this was catastrophic from numbers of points of view. Firstly, the Post Office obtained a costs order against Mr. Castleton of £321,000. That's on a claim for £26,000. You may stand back and ask yourself, well, what is a large public institution spending £321,000 recovering a judgment on £26,000 against a small business operator? Well, the short answer to that is the Post Office was able to use that judgment in two senses. Firstly, it was able to say, well, look, we've got a High Court judgment now in which the trial judge has found Horizon to be working perfectly. Well, that was fantastic for the Post Office, because if you show a High Court judgment to any ordinary small businessman which says the Horizon system is working perfectly, you have got a problem on your hands. And who is going to stand up to that? Basically, your requirement is to get behind that judgment and say that it's wrong, whether you go to appeal or not. You can accept that you're going to lose first time around, say, well, I'm still going to go way up to the Court of Appeal. Well, who's going to do that for the kind of comparatively modest amounts that are an issue in most of these proceedings? There were very few of them where there would have been sort of about £500,000 at stake. Most of them would have been tens of thousands. And the other aspect of it is that the costs were so huge compared to the amount at stake that it was possible for the Post Office to say, well, look, if you take us on, it cost Mr. Castleton had an adverse cost order against him of £321,000. How does that sound to you? And the other consequence of it, it was totally devastating for Mr. Castleton. He was made bankrupt. That judgment is still outstanding against him, hasn't yet been set aside, and it totally devastated his family. He was reduced to penury, really. For a year afterwards, his family lived in accommodation without a hot water boiler because they couldn't afford to have a hot water boiler repair it. And his young daughter, I know he wouldn't mind me saying this, suffered from such severe anxiety as a result of the impact on the family that she developed anorexia and was admitted to hospital on 3 separate occasions, including at risk to her life. The reason I say that is it's easy to think about these things as miscarriages of justice as sort of abstract notions. A miscarriage of justice is harm inflicted by the state, by courts, on individuals that devastate their lives. And every single one of those 39 cases represents a life that has been wrecked, a family's life that has been wrecked, and time that has simply been lost forever to those concerned. Tracy Felstead was 19 when she was imprisoned, and it took her until, that was in 2002, and it took her until 2021 to clear her name and have her conviction quashed. For the entirety of her adult life, she had that conviction hanging over her. As a result of my becoming interested in Lee Castleton's case, I became acquainted with some other former postmasters, including Seema Misra. And the consequence of that was that I was aware by the time I agreed to act for them, by the time I agreed to act for Tracy Felstead, Janet Skinner and Seema Misra, I'd spent several hundred hours looking at both transcripts of Seema's trial, also the Horizon issues judgments. And I came at this case knowing when I was instructed formally on their behalf, I knew that the Post Office had given misleading evidence in certainly in its prosecution of Seema Misra. And so there was a very important development. In October 2020, the Post Office put in its respondent's notice to the Criminal Cases Review Commission referrals, which is effectively the appeals to the Court of Appeal. And very much to my surprise, the Post Office said that it wasn't going to contest 39 of the appeals, and it accepted in each of those appeals that it had given inadequate and incomplete disclosure of Horizon records. And so the consequence of that for the lawyers concerned was that those 39 appeals were almost bound to succeed, because the Post Office was not going to resist them and wasn't going to try and uphold them. Well, short of that doesn't mean that they were bound to succeed, because quashing of a conviction is ultimately in the power of the court. It's the court's decision, not the prosecutor or the respondent's decision as to whether a conviction should be quashed. It's always for the court. So, but it was almost a racing certainty that those appeals would be allowed. So that when the Post Office was making disclosure, it was producing new documents all the time in autumn of 2020. There was really no great imperative on the part of the lawyers concerned to be particularly concerned about further disclosure, because they knew and they could be confident that when it ended up before the Court of Appeal, subject to a very surprising development, which was not anticipated, the Court of Appeal would grant the appeal and quash the conviction. But I was coming at it from a different point of view. I knew that misleading evidence had been given in Mrs. Misra's case. I knew that in relation to two things. One is I knew about receipts and payments mismatch bug, and I also knew about an issue called remote access. And on those two issues, the Post Office had given by its witnesses misleading evidence to the court, plain as Pikestaff. One of the grounds of appeal which the CCRC was putting forward in its referral, which was filed on the 6th of June of 2020. It's a very long document which annexes to it Mr. Justice Fraser's judgments. The CCRC was contending for what's called second category abusive process, and it really did this on a basis which was, in some respects, curious. It contended that the Post Office was not a prosecutor in good faith, or that it was a bad faith prosecutor, and the reasons for that are not necessary to discuss at the moment. But the consequence of that and the ground of appeal was that the CCRC submitted to the Court of Appeal that that an additional ground of appeal was what's called second category abusive process. Now, this is of immense importance and became of immense importance. Second category abusive process, unlike first category abusive process, is concerned not with the way in which a particular trial has been conducted, but with the conduct of the prosecutor. And so you move the focus away from did the defendant in question get a fair trial? Was there some failure in disclosure or something like that? And you move to the conduct of the prosecutor, and you say, was the prosecutor conducting the prosecution in a way that maintained the integrity of the criminal justice system, that was in accordance with principle and upheld the criminal justice system? Well, why is this important? Well, a prosecutor, including a private prosecutor like the Post Office, assumes the mantle of the state. A prosecution is a state function, and the coercive power of the state in the consequences of the prosecution are engaged. And so it is of the utmost importance that a prosecution is conducted in a proper way by the prosecution. Because if that doesn't happen, the consequence is that the justice is destabilized or undermined or put at risk, doesn't matter how you want to put it. And if that happens, you put at risk public confidence in the criminal justice system. Well, these are very, very big issues, and they really matter. And so when the Court of Appeal is concerned with conduct that is characterized as second category abusive process, it's concerned with two things: conduct which subverts the criminal justice system, and conduct which puts at risk public confidence in the criminal justice system. These are very, very big deals. Now, the Post Office ran this argument, and not surprisingly so in a way, because what it more or less said was, well, look at this number of prosecutions the Post Office has brought. They're all based on horizon evidence, and the evidence was, to use sort of popular parlance, was dodgy. Well, that's a bit wrong. Well, the Post Office, the CCRC, in my view, didn't really make a terribly good fist of that. And in written submission to the Court of Appeal, I explain why not. Now, without getting into technical details, the thing that I had in my mind was that I knew that the Post Office, at least in the Mrs. Misera's case, which was the one where I'd seen the full transcript, I knew it had given misleading evidence. So any document that came to my attention, I was interested in, because I wanted to see what else we might be able to find from the Post Office. And the most remarkable thing, really, and in a sense this cuts to the heart of it, was that in late October of 2020, my junior and I, and my solicitor, I was fortunate to have a very able junior in Flora Page, and my solicitor at Aria Grace Law. We received late disclosure from the Post Office, and this was much later than it should have been given, because we had to put in our written submissions to the Court of Appeal in October. This at the beginning of October, and this was coming on 23rd of October, I think. And in 4 lines of text in a very long document, I saw that the Post Office main board had been notified of concerns about the person who gave evidence against Mrs. Misera at her trial in 2010 about both the completeness of his evidence and the completeness of disclosure. Now, this was completely electrifying to me, because I hadn't seen a single document up until that point which tied what was happening on the ground, if you like, in prosecutions, that tied that to the Post Office board. That is, the knowledge of the Post Office's main board about what might be happening. Now, this was the first reference I'd seen to that, and the person's name, Mr. Gareth Jenkins, was the Fujitsu expert who gave evidence at Mrs. Misera's trial. So when you put those two things together, you've got a board linkage, and you've got a linkage to the person who gave evidence against Mrs. Misera at her trial, which I knew in any event to have been, in respect, misleading evidence. I was, whether you want to say my ears pricked up or my antennae started twitching, it doesn't matter. But I was very interested in this, and my solicitors wrote a very long letter to the solicitors for the Post Office, Peters and Peters, and we asked, what is going on here? The board is being notified. And what came back, several documents came back, which we haven't got time for, but what came back was one of the most startling documents that I've encountered in 30 years practice at the bar. Effectively, to cut a long story short, it was an external written opinion by solicitors, a firm called Clarke King, a barrister employed by Clarke King, in which, because the receipts and payments mismatch bug had been flagged up by Second Sight. This is another dogleg to this story, but Second Sight was a firm of forensic accountants who'd been engaged at the instance of Parliament under parliamentary pressure from 2012. They'd picked up the existence of the receipts and payments mismatch bug in an interim report that they provided in the summer of 2013. In response to that, the Post Office obviously instructed external solicitors to investigate this. And what they did was they reviewed 5 separate prosecutions in which Mr. Jenkins had given evidence in the form of reports. It later emerged he'd only given evidence orally in one case, which was Mrs. Misera's case. But he'd given 5 reports to the court in 5 separate cases between 2012 and 2013. That's important because, in fact, he'd been the go-to expert for the Post Office for many years. That's recorded in the advice that was disclosed. In every single one of those cases, the writer of the opinion concluded that he had given misleading and incomplete evidence to the court because he knew of the receipts and payments mismatch bug, amongst other things, but he had not disclosed it. And the writer records that put the Post Office in breach of its obligations to the court as prosecutor. And another thing that it suggested, the writer suggested, was that he should never be used as a witness again in proceedings by the Post Office. Now that's electrifying, because basically it's recognition in 2013 that the Post Office knew not only that there were bugs, but the evidence in relation to those bugs had been given to the court that was misleading. Now, I mean, to cut a long story short, and to grossly oversimplify things, what the Post Office did in response to that in 2014 was in one sense inevitable and wholly unsurprising. It stopped prosecuting postmasters for shortfalls evidenced by Horizon. But what it didn't do was to communicate that knowledge, or any of that knowledge, to its postmasters or to those who it prosecuted, to enable them to appeal. And the consequence of that is, well, it was worse than that. It didn't disclose it, but it actually suppressed and sat on the knowledge that it did have and withheld it, both from the courts and from those that have prosecuted convicted defendants, right up until it conceded in October 2020 that a very large number of prosecutions were unsafe. That in a sense is part two. And that had really catastrophic consequences for defendants, because Article 6 of the European Convention on Human Rights guarantees everyone a fair trial within a reasonable period of time. That's a right that is guaranteed by the state. Additional to that, or part of it, is a right to an appeal within a reasonable period of time. And what we know, I mean, if I take my three former clients as examples, what we know is it took Janet Skinner, Tracy Felsted, and Seema Misra a combined total of 44 years to have their convictions overturned. 44 years. And you only need to reflect on what 44 years divided by 3 in terms of your own life and what that time represents. Now that right was denied to them by the Post Office. It was denied to them by the Post Office, and it's not something that accidentally happened. It's something that is the consequence of deliberate act and design. The withholding of material from a person who has a right to that material in law, and there's a basic proposition of law that a convicted defendant has a right to information from the prosecutor that comes to their attention, that casts doubt on the safety or safety of that conviction, or might put them on inquiry as to whether that conviction might be appealed. They have a right to that information, and it was withheld from all those the Post Office prosecuted. And in a sense, one of my criticisms, the Court of Appeal judgment, of course, in April 2021, is greatly welcomed, and that the court found that there was second category abuse of process in 39 of the convictions that it's quashed, is of course of enormous importance, because without that finding, we can be entirely confident that the inquiry by Sir Wynne Williams, which has been put on statutory footing, wouldn't have been put on a statutory footing, which it was in June 2021, almost immediately after the Court of Appeal decision. And the other thing that wouldn't have happened is that the government now would not recognise that the compensation paid to those who the Post Office prosecuted and other things is inadequate, and the government has confirmed that it's going to step in and meet and pay and fund the additional compensation to which they're entitled. We know that in 2013, the board was notified that there was notified of knowledge that its prosecutions in numbers of cases had proceeded on what can only be described as a false basis.
Yeah.
The board knew that.
Yeah.
That's what it was being told in 2013. We know that it ceased prosecuting in 2014. I guess this is where you went into inferences. It knew that we know that it ceased prosecuting in 2014. Why did it do so? Well, presumably because it knew that the basis for those prosecutions was unsound. And we know that the defendants whom it had prosecuted were not given information to which they were otherwise entitled that would have enabled them to successfully appeal their convictions. One can't say with confidence it was a board-level decision. What we can say with confidence is it's a strategic decision. Mm. And it's a strategic decision in connection with legal rights. And therefore, on the face of it, it's the result of a legal strategy. So what you can deduce from that is that lawyers were involved in determining that strategy. Mm. At what level and who and instructed by is another question. See, the Court of Appeal's judgment in many respects is welcome, and the fact that the Court of Appeal went so far as to make the finding on second category abuse of process is of immense importance. And when I was contending for that, it's fair to say that but for me having cancer, that finding would never have been made, because I was at the end of 2020 the only lawyer, together with Flora Page, my junior, contending for that head of that ground of appeal. All the other lawyers in the case told me that I was wrong and I didn't know what I was talking about, and the Court of Appeal would neither entertain it, and even if they did, they would reject it when they considered it. Now, the importance of that is that having made that finding, that has had immense consequences, in particular for the defendants, because although it's not necessary for a finding, a claim for malicious prosecution, it obviously gives and strengthens a defendant's claim for malicious prosecution, given what we now know about the Post Office's approach to its prosecutions. I mean, the Court of Appeal basically found the Post Office was engaged in conduct that subverted the criminal justice system. But the important thing about that, in my view, and where you move from the Court of Appeal's judgment being satisfactory to being, in respects, very unsatisfactory, two things. Firstly, as a matter of law, the Court of Appeal ought, when there has been manifest unreasonable delay in an appeal coming on and being heard, which in almost all these cases applied, because, you know, Tracy Felsted was convicted in 2002 and she has her appeal heard in 2021. Well, the first question is, why is that? And as a matter of law, the court, when it has evidence that there's been undue and unreasonable delay in an appeal being heard, the court is bound to inquire into what the reasons for that are. And the Court of Appeal simply didn't. You get the impression from the Court of Appeal's judgment that it was trying to confine itself, so far as was reasonably possible, to deciding as little as possible in April 2021, which is unfortunate, because the other question, which the Court of Appeal has two fundamental functions. Its primary function is the reviewing function, concerned with whether or not a particular criminal conviction is safe or not. And its second function is concerned with the supervision of what are referred to as the inferior courts, how the junior courts conduct criminal trials. And in the Post Office appeals, the Court of Appeal entirely put to one side its supervisory role. It was not concerned with how these many convictions had actually come to be unsafe. Of course, it was concerned with its reviewing function, which was whether the convictions were unsafe, but why they were unsafe and how trials had been conducted was an issue that they did not go to, did not address. Why did this happen? The Court of Appeals got an unprecedented number of appeals in front of it, all turning on the same issue: incomplete evidence, unreliable evidence, misunderstood evidence, over time, all prosecuted by the Post Office. You know, one's tempted to say, well, the obvious question is, why did it happen? And that was a proper question for the court to address. And when you start to ask the question, well, when the question is raised, why did it happen? That, of course, raises the anterior question, well, what did the Post Office know when it was undertaking these prosecutions? Court of Appeal didn't go there, and it's in a sense parked the issue. Well, it's that's a bad observation in a sense. It's not just what the Post Office knew. The question is, why did the courts routinely fail to recognise that the evidence before the court that was being put forward by the Post Office was incomplete and unreliable? Why did that happen? That's a massively important question that needs to be addressed. And it really comes full circle to where we started. Computer evidence is on the whole poorly understood by the judiciary. I've said in other places that if the criminal justice system in the UK was an airline, nobody would fly it, such as in the instance of failure. If you had 736 people being killed in aircraft accidents, there'd be an outcry, and the relevant aircraft would be grounded and stopped until there was an answer to it. You know, if you've got hundreds of people in the United Kingdom being prosecuted on a false basis and wrongly convicted and sent to prison, with all the consequences that follow from that, ordinarily you would think that there would be an urgent drive to establish why it happened and to make sure that it bloody well never happened again. The courts, in one respect, you get to a sort of fundamental questions. Our public life depends on a very high level of abstraction on individuals feeling that or perceiving that their interests are represented by their parliamentary representatives and they have a voice in Parliament, and that there is a sort of accountability of the government to the electorate through their representatives, through their members of Parliament, and that it's a sort of two-way process. The legal sort of counterpoise to that, or the sort of, this is badly expressed, but an analogue of that is that ordinary people need to feel and perceive that their grievances, if they have grievances, if they suffer a wrong, and so on, they will be rectified and properly addressed through the court system. Similarly, that if you're prosecuted for an offence in the court system, you will get the right result. Courts exist criminal courts exist to acquit the innocent and convict the guilty of offences that obviously the law regards as impinging on the interests of the wider public and engage the interests of the state. Now, that albeit not very well expressed, the courts are, like the Post Office, very concerned with confidence, and the court system depends on public confidence, and it's very concerning when you have circumstances which raise serious and far-reaching questions about the competence and integrity of the criminal justice system. And it's probably right to say that the senior judiciary are very sensitive to the danger of a public perception that criminal justice is essentially unreliable. I mean, if you're a member of the public and you start to feel that if you're prosecuted, you might not be acquitted, even though you're wholly innocent, and you might be convicted of something of which you are innocent. That puts at risk public confidence in the administration of justice more generally. And so the recognition, the public recognition by the courts, by the senior judiciary, that there is a systemic problem here is one which has to be approached with the greatest caution and circumspection, really, because of its potential impact on public confidence.
And so the right thing to do is to pretend it hasn't happened. Is not to ask, not to look.
That's probably putting it at its highest and in its worst light. I think a gentler way of putting it is not confronting it head on because of the potential implications of doing so for public confidence, which is not quite what you said, but a sort of slightly gentler and softer view. And I think it is those considerations which are in play at the moment, because to any ordinary person knowing about these circumstances, the first question is, well, when the courts approach computer evidence, what is to be done to prevent this happening again? And at the moment, so far as I know, nothing is being done. But there is an urgent requirement, it seems to me, for two things. One is the Law Commission ought to revisit what it recommended in the late 1990s, when it recommended the abolition of the protections of computer evidence. Because we know, I mean, it doesn't need a particularly deep insight to know that if the Post Office had been required to prove the reliability of the source of the information from which of the evidence that it was relying on, it couldn't have done so. Couldn't have done so in any case, not once. And it took until 2019 for that point to be established, simply because the courts are told, well, you know, this evidence can be relied upon. One of the great lessons, really, for any lawyer from the Post Office scandal is that marks on a bit of paper are only marks on a bit of paper until in court proceedings, until somebody proves to the court what they mean, and if they're a statement, that the statement is true. It's quite simple, really. It's like evidence in court proceedings generally. The only requirement is to have the relevant evidence and then to evaluate the evidence. But if the judges can't properly evaluate the evidence, you really are out at sea without a paddle. And it's a very serious situation that's emerged. And the fact that it happened at all stands as a very serious reproach to the criminal justice system. I think I would go so far as to say that the Post Office scandal suggests that the criminal justice system in the United Kingdom is not fit for purpose. Because if people are being routinely convicted in this kind of way for in a sense, the simplest of reasons, and things going so terribly, terribly wrong with such catastrophic consequences, how can you say any more than you would say that an airline that crashes and causes people to die? You know, an airline exists in order to transport people safely from A to B. Courts exist in order to convict the guilty and to acquit the innocent. Well, frequently that doesn't happen.
It's an interesting question as to whether things will shift under the surface. You know, that people will take this issue seriously and actually do something about it, because there is a feeling in public life at the moment that people are getting away with murder, and that elites can get away with anything they like if they pay enough to a lawyer to achieve it.
In a sense, you might say that a emerging contemporary feature of English public life is lack of accountability. And we see that in Parliament, and we see it in the government. And perhaps one of the most remarkable aspects of the Post Office scandal is that the chair of the institution that wreaked so much damage over so many years through the courts, the chair of that institution, Tim Parker, is also the chair of Her Majesty's Courts and Tribunal Service. That is a quite remarkable circumstance where you stand back and look at what the Post Office did through the courts and the way in which it abused the court system and subverted the criminal justice system, as the Court of Appeal has found. It's quite extraordinary that the board of the Post Office and its chairman that oversaw the litigation, that squandered tens of millions of pounds of public money in keeping from the courts and resisting the truth emerging. It's quite extraordinary that the board that had conduct of those things remains substantially unchanged. If the Post Office was an ordinary corporation and it had ordinary shareholders who held it to account, that board would have disappeared within 2 months of the finding of Mr. Justice Fraser in the Horizon judgment in 2019, let alone the Court of Appeal's judgment in April 2021, finding that the Post Office had routinely subverted the criminal justice system, and how they remain in place, and how the chairman happens to be also chair of Her Majesty's Courts and Tribunal Service remains to me utterly bewildering.
But the uncomfortable parallel with that is the conversation we've recently had with Ian Fraser, discussing the Royal Bank of Scotland and their conduct and the civil service and Bank of England roles that people have played, as part of that scandal, with a similar issue about who's in charge and what was their involvement in the previous scandal.
And if you want to understand that, you need to go back to the Scott inquiry on the Arms to Iraq scandal and see what he said about the civil servants who appeared before him. You'll remember what that was about, the Arms to Iran scandal. Matrix Churchill was the company that was involved. And very memorably, it just sticks in my mind, one of the senior civil servants to appear before him said this. I'm obviously paraphrasing, but it's from memory. He said, "Truth is a very difficult concept." Well, that might be said to be the sort of an expression that applies to a rather great deal of public life at the moment.
Do you think the Court of Appeal will actually do nothing at all? It's going to hear a lot more of these cases.
Well, it's exhibited no interest publicly in saying more than it has said in connection with the individual decisions before it. It seems to have no appetite to make any broader statement or pursue any further inquiries, which I think is very dispiriting, really, given its public function and its responsibilities. And it strikes me as being very unsatisfactory. So, well, that's all being dealt with by, I'm not suggesting this is what's being said, but some people take the view, well, there's the statutory inquiry being conducted by Sir Win Williams, and that will provide the answers. But it won't provide the answers to these questions, because he is not concerned with court failure. The remit that he has and his increasing the scale and scope of his inquiries, which he's made very clear, they're encouraging, but they don't extend to court failure. And as I've said from the beginning, there are two aspects to this. One is the Horizon, is the Post Office responsibility and what I've described as mendacity, which I think is an apposite expression. But that's really Sir Win Williams' remit in his inquiry. Court failure is the second limb of this. And the question is quite straightforward as to why it happened. We know why it happened, because courts don't frequently understand computer evidence and the relevant evidence and what that evidence is. And that really, it seems to me, needs to change, and there's an urgent requirement for change. The other thing is, I think, sitting back from it, when you look at the sheer scale of suffering inflicted by the Post Office through the courts. I started by saying, I said a while ago, miscarriages of justice. Miscarriages of justice, a miscarriage of justice is state-inflicted harm. That's very important to recognise. It's harm that is inflicted on individuals through the agency of the state by the courts. It's a terrible thing. It's really difficult to overstate the impact that these prosecutions and convictions have had on individuals' lives. Janet Skinner, who I was privileged to represent, she was prosecuted and encouraged to plead guilty to the charges against her in the hope that she would avoid a custodial sentence. She was imprisoned in any event despite that, always protesting her evidence. To her barrister and counsel at the time, she protested that she'd never taken a penny, didn't know anything about it. She was persuaded to plead guilty. She went to prison. She had 2 young children at the time. When she was released from prison, she received a further letter of demand from the Post Office, demanding yet more money from her. She suffered a complete nervous collapse at the time. She was admitted to hospital with a suspected stroke. She was told she'd never walk again. And even now, she can't walk properly. She's never worked again since the time of her conviction in 2007. It's completely blighted her life. That's a miscarriage of justice. Tracy Felstead, just before the Court of Appeal hearing in November 2020, she was admitted to hospital with a suspected stroke. Why? She hadn't suffered a stroke. She'd had a complete nervous collapse. Why? The stress of the court proceedings. These are people who now look at the courts not as places where justice is done, but as places to be terrified of and to be feared, because they're places where injustice is done. Now, that's a very, very tragic outcome, and it's very dangerous for society.
But there are parallel stories we're hearing from the family court as well, of a similar sort, of people who experience the family court as being
dangerous to attend.
A very dangerous place for them. They lose their children, and again, disastrous effects on families. I'm sorry to interrupt you, but there are so many examples popping up of this kind of dynamic going on in public life.
Well, it's very dangerous. It's very dangerous in the same way that once people start to feel that Parliament is not representative, is not an institution which is indifferent to their interests and concern, and is unaccountable, you start to have the seeds of serious problems. And it is the same with the courts. The court's legitimacy depends ultimately on public confidence.
Yeah.
And once you start to chip away at that, there emerges a real danger for the body politic, if you like.
And the people doing the chipping are the people in the industry, as it were. Are the people?
Well, I agree with you. I agree with you. And you asked at the beginning of this discussion, well, where is the greater fault? Is it the Post Office or the courts? The courts allowed themselves to be bamboozled by the Post Office for 20 years. That seems to me to be a really big deal. And I would say that the circumstances are so serious and the scale of harm is so extensive I think if I was in the position of the Lord Chief Justice, I would be making a public statement about this and what lessons are going to be learned by the courts from it in order for this to be prevented for the future. Because another aspect of this is the Post Office postmaster's convictions would never have been overturned but for the Horizon Issues judgment. I think that's a reasonably fair thing to say. That judgment required 550 claimants to join together in civil proceedings to take on the Post Office. It required 550 claimants. It ultimately resulted in a settlement of some £57 million. That £57 million, 80% of it went to the lawyers and to the funders of that litigation, with the balance to be distributed amongst the 550 claimants. Now, they all received pitiful sums. Tracy Felstead wouldn't mind me saying that for her experience of prison at the age of 19, in the course of which she found tragically a fellow inmate hanged, she received £17,000. When I first spoke to Tracy, well over 18 months ago now, in our first conversation, I pressed her to tell me how much she had received, and she was principally concerned about her conviction being quashed. She told me that she'd received £17,000, and I was unable to speak for about 2 minutes. I was so shocked. Now, why do I say that? Because this entire saga raises a very, very big question, which of course we don't have time at all for today, which is access to justice. If it takes 550 claimants to incur costs of millions of pounds to bring a claim against a state institution such as the Post Office, to elicit evidence and information that should have been produced years ago in most cases, and the outcome of that litigation, which takes place over a period of years, is that a claimant receives £17,000 for being imprisoned by the entity they were engaged in suing. That suggests to me that there is substantively a denial of access to justice by the courts, because that can't be a sensible or reasonable outcome of litigation on this scale about issues of such importance, where the underlying principles are so basic. There is something that is going deeply and seriously wrong. The Court of Appeal has two fundamental functions. Its primary function is the reviewing function, concerned with whether or not a particular criminal conviction is safe or not. And its second function is concerned with the supervision of what are referred to as the inferior courts, how the junior courts conduct criminal trials. And in the Post Office appeals, the Court of Appeal entirely put to one side its supervisory role. It was not concerned with how these many convictions had actually come to be unsafe. Of course, it was concerned with its reviewing function, which was whether the convictions were unsafe, but why they were unsafe and how trials had been conducted was an issue that they did not go to, did not address.